We are live with SCI TV. I'm Joshua Gordon from the Sports Conflict Institute, joined today by my very special guest, attorney Chris George. Chris, how are you?
I'm doing well. Thank you very much. How are you?
Thanks for joining. You and I have known each other for a long time through running and through law school, and it's really a pleasure to have you on to talk about what's been going on with an investigation USADA has been conducting around the Nike Oregon project.
Yep.
So Chris, you wrote a piece recently for Let'sRun.com that I thought would make a nice foundation for us to talk about. Can you give a little background and summary of what's been going on? Running and track and field is a sport that some people follow passionately. Certainly those on Let'sRun.com do. You are a fan. I am a fan as well. We're heading into Olympic year. It's an important topic, but not everyone knows the context and the background. We've got folks from all walks of life watching this show. So give a little background, and then let's dig into some of the thoughts that you have on this subject.
Okay, sure. Nike Oregon project was founded many years ago by Alberto Mozart for Nike. And it was his way of trying to create a specialized group of very elite individuals who are going to contend for Olympic medals. It was, and it's something that he's built, and he's built into a very, very talented organization. And this coming Olympics, you're going to see Mo Farah, you're going to see Galen Rupp and Matt Centrowitz competing, and they're all legitimate medal threats in various distances. So they also had an assistant coach named Steve Magnus, who was a coach up until just prior to the 2012 Olympics, and that was in London. And he, if you believe this piece that was published in ProPublica last summer, he left because of some questionable conduct with some of the observations he made, and he believed there may be some cheating going on with respect to possible doping. And this is just going back to the ProPublica piece. They supposedly were approached by 17 staffers and athletes who observed, again, questionable behavior, questionable conduct. And some of this, maybe all of it, led USADA to open up an investigation, which my understanding is something they've been actively working on up until present day. So that's generally where we're at. And the latest news came out of an attempt by USADA to try to get a doctor who I guess is a common endocrinologist for Nike Oregon Project athletes. Now, he's based in Houston. The Oregon Project is actually based up in Oregon, where you are. So the USADA wanted to try to get some of this doctor's records, and they were able to get some of the records. They wanted, my understanding is they wanted more than just what they had the authority to get. They also wanted to get the doctor to testify about his treatment of these athletes. So that's the general background behind this.
So very interesting, and so obviously what's going on right now is USADA's trying to figure out where things are on this and trying to conduct an investigation. From a legal perspective, and this is where some of your analysis gets particularly interesting, what are some of the tools and barriers that USADA faces in terms of conducting an investigation like this, where they're trying to figure out whether or not the practices of the Nike Oregon Project are consistent with the rules and regulations of the sport, or whether they've stepped over a line and violated some of the integrity issues?
Well, USADA is it's a nonprofit organization, and it's a non-governmental entity as well. So essentially, when people come to speak to USADA, they have to do so voluntarily. USADA has very limited options to try to force somebody to sit down and talk to them. And the same can be said for they're trying to obtain records, especially medical records. They don't have the power to subpoena, which is very important. As a lawyer, for instance, if I'm in a lawsuit and I want to get medical records, I can try to subpoena them. I can even try to compel them by a court order. USADA doesn't have that power. And so that's one of their biggest limitations in all of this, is that they're trying to conduct an investigation that really depends more on cooperation of others than it does that power of force that, for instance, a lawyer might have representing a client.
So from your perspective, is that an effective setup, the way we have USADA set up as a nonprofit charged with the integrity of sport, where they have some limits on their power, or could there be a better model from your perspective?
Well, I think it's important to note that if you test positive for a banned substance under the WADA code, for whatever that say it's some kind of a medication that you're not supposed to have in you. In the United States, that's not a crime, and I think that's very important because there is a difference between doing something where you're cheating, you're doing something that could be considered cheating at an international event versus where you're actually breaking the law. And I think that's an important line to distinguish. And that's, I think, part of the reason why USADA doesn't have that power of subpoena.
So I imagine one challenge with a lot of this is so much of it is getting played out in the court of public opinion. And there are a lot of folks trying to make sense of leaks and stories and facts as they come out. To what extent is the legal process able to keep up with some of the things that are happening in real time through Twitter and sites like Let's Run and other things? How well equipped is the legal system to deal with these types of challenges?
Well, I mean, do you mean the legal system or USADA's investigations?
Well, both really, because in some ways we run parallel processes where USADA is trying to figure out what constraints it has and how it can leverage some of its own powers, but then at times they're trying to figure out if there are other mechanisms. For example, if someone took a medication that was not prescribed to them or had some other way to which they violated a law, that could have been a way for them to backdoor into some information as well.
Well, I mean, USADA, when I look at USADA, I'm sure is constantly monitoring, social media, and it's receiving information from a variety of different sources. If athletes see something, they can always report it confidentially. And my understanding is that was done with respect to this Nike Oregon project situation. So they can always do that, and they have the power to conduct unannounced drug tests. If you're an elite athlete in the United States, you have to let USADA know where you are at all times, because they can find you and just decide to conduct a drug test. So I think that's a very powerful tool in their arsenal to make sure that every one of the athletes are in compliance with the WADA, with the various doping codes. Now, with respect to trying to do things legally, that's where it gets into a little bit of a murky situation. What you often find is with USADA, and something I mentioned in the article about Lance Armstrong, what they did is a lot of the information they gained, they piggybacked off of federal prosecutors who were conducting separate criminal probes into tax fraud, or I know one of the issues was Lance was riding for the U.S. Postal Service, and did he commit fraud in that contract, because one of the I presume one of the responsibilities was he was supposed to be a clean athlete, and it was coming out that he might not have been clean. So using transcripts and documents that were produced in those investigations, USADA was able to compile a pretty compelling case to say, hey, we think you cheated, and we're going to suspend you for the following years. Now, with respect to this Nike Oregon project, they obviously have statements from witnesses. They're trying to collect records that they can, but like I said earlier, they're a little hamstrung by the fact that they cannot subpoena and force people to appear. And they're certainly not going to be able to get, for instance, medical records of people who don't voluntarily want their medical records released.
And do you get a sense from, I'm not sure you spend a ton of time on Let'sRun.com, but in general, when you're talking to track and field fans, you get a sense of whether or not there's a presumption of guilt and then someone has to prove themselves innocent in their eyes, or is it the other way around where people are giving Nike Oregon project the benefit of the doubt and then waiting to hear what information comes out?
I think people just have gone into this with a bias one way or the other about whether or not, because some people view Nike as the evil empire, and some people look at Nike and say, hey, look, they've done more for track and field than any other footwear and apparel company, could do. And so I don't think that this necessarily changes anyone's view one way or the other. Specifically, I think, frankly, the ProPublica piece was pretty damning last summer, just because that certainly weighed heavily in the court of public opinion. This right here is just USADA wanted to get some medical records, and a text, and then when they didn't have the power to subpoena, they tried to get around that by trying to file a Rule 202 request, which would have put the doctor in a deposition, and Texas court said, yeah, we're not going to allow this to happen. If you're reading this and you think Nike is evil and trying to cover something up, then you're just going to say, well, then what do all these people have to hide? What do the Nike Oregon Project athletes have to hide? Why not just let the doctor talk about everything? But frankly, I looked at this and just saw that USADA was trying to make a doctor testify under oath on camera about patients he didn't have the authority to discuss, and that's why there was a lot of pushback by the doctor. And so I don't necessarily attribute what happened here to Nike trying to hide something or Alberto Salazar trying to hide something. I think it was really just USADA trying to get information that they didn't necessarily have a legal access to obtain, or legal right to obtain, rather.
Yeah, I imagine the doctor's in a very difficult position given what you're saying around the idea of an expectation of privacy and what that relationship is with your physician, that you don't expect that your physician is going to be sharing all kinds of details of your medical history and treatment plan.
Well, I guess let me lay it to you this way. If as a lawyer, say USADA comes to me and says, I've got permission for you to talk about client A. Oh, and by the way, I want you to talk to us under oath on camera, and while we're at it, I want you to talk to me about clients B and C. If I say, no problem, go, let's have a field day. I'm going to get sued by clients B and C for legal malpractice. I'm going to get disbarred by the Massachusetts Board of Bar Overseers. That's happening. That's a certainty. My career is over, and I'm going to be in a lot of trouble. Now, if you replace clients with patients, I change me to a doctor and the Mass BBO to the State Medical Board, that's exactly the situation that this doctor was trying to be put into. I don't blame him at all for saying absolutely not. I actually think too that the way the judge in Texas ruled was the right decision.
Yeah, and yet the optics become challenging nonetheless, don't they? Because for a lot of folks that, just to your point, they're saying, well, if you have nothing to hide, why don't you share it? And so the non-testimony, the non-information becomes information certainly in the court of public opinion. But I wonder how that information is used by USADA. Any thoughts on how USADA takes that non-compliance and what they do with that?
Well, I mean, when you say non-compliance, are you saying that an athlete's refusal to just voluntarily give up his medical treatment as non-compliance?
Yeah, I think USADA comes in with the expectation that anything they ask, they're going to get an answer to, and then if there isn't, it's seen as something potentially suspicious.
So you're saying a lack of transparency implies guilt?
Perhaps, and that's a thread I'm at least interested in, is whether if you were dealing with USADA, are you constantly on a defensive posture if you're an athlete or a coach or a doctor and trying to say, look, I know this looks bad, but I have lots of valid reasons I can't share that information? Or is there much more of a feel like there's a process that's just going through and there's an understanding that, okay, yeah, I know why you can't share that information, and we'll just continue to try and clear your name as well? I mean, is it seen as an advocate for clean sport, or is it seen as someone where they really feel like they're under a harsh investigation?
Well, I guess the way I'd look at it is, the way I've sort of looked at this is maybe one of the people they're really trying to go after is someone like Galen Rupp, because he's the superstar of the Nike Oregon Project. Mo Farah, to his credit as well, but I think as far as I remember, back when I just graduated college, it was formed around Galen Rupp. He was going to be the future of distance running. So if I'm Galen Rupp, I've got this ProPublica piece that comes out with people accusing me of taking, getting special saline solutions after competitions. Perhaps I'm having special massages in which Alberto Salazar is rubbing a cream that may or may not have testosterone in it without my knowledge. There's all of these things that are being raised about me. And if I'm Galen Rupp and I think I'm clean, and then USADA comes poking around saying, we want access to all of your medical records, we want access to A, B, C, D, and E, and they don't necessarily have the right to, in some ways, I feel like I'm being attacked, and this is a witch hunt, just out to try to find anything that they might be able to try to somehow connect into a charge against me. You know what? I'd say at some point, I'd say enough is enough, and absolutely not. At some point, you have to feel like if you really are clean, it's easy to see how you could feel your privacy is being violated, if that makes sense. You know, but at the same, and that's how someone who is a staunch supporter of Nike would probably feel. Whereas if you think Nike is dirty and you think that they're evil, you're just, yeah, this is just going to be one more reason to say, if you're clean, then what do you have to hide? And I guess it's really just which side of the fence are you on?
Yeah, I think, Chris, one important part of this to highlight too is the whole therapeutic use exemption process. Could you give a little bit of context of what that TUE process is and why that comes into play a little bit with any of these investigations, why the doctor's information becomes even more important in that context as well?
Well, I mean, certainly there are certain medications, you know, for instance, maybe you have asthma, or I suppose, I don't know if this thyroid condition would necessarily apply to it, but you file for an exemption where you're saying, I'm on this medication, I'm taking it because I have a legitimate medical reason for it, and so you get permitted to be on it so that when you compete in, say, the US Olympic trials or the Olympics in Rio, you know, and maybe it comes up, yeah, they're on this medication. Oh, but you know what? They declared it. They were given permission to compete while they're on it. So there's no violation of our doping code, which means your result can stand and you won't be disqualified or potentially, you know, punished with a, you know, 4-year ban or something. That's generally what a TUE is. And there have been allegations against the Nike Oregon project for overusing TUEs, and that was sort of how Dr. Brown came into view here. Was that I think if I remember from Kara Goucher's statements and some of the other athletes, they would be forced to run on a treadmill probably to exhaustion. They would get tested, and presumably it was a fraud of a test where it was just so that they could justify, oh, your thyroid seems to be off. It's not functioning properly. We're going to give you this medication, and that's going to fix your problem. Oh, you may need a TUE, so here's that. That's at least one of the allegations, if I remember from the ProPublica article from last summer. Of course, I've also seen stories that, for instance, the thyroid medication may not actually improve performance. If I remember correctly, too, there was a request for the WADA to put it on its banned substances list, and I think they denied that request, because I think the medical evidence doesn't support that it's a performance-enhancing drug. Yeah, it's something to be determined, I guess.
And one of the real challenges here is that certainly USADA's got an uphill battle in terms of trying to preserve integrity in sport. And for those of us who care about integrity in sport, and there are a number of us out there who do quite a bit, you and I included in that group, it's really challenging because what are we left with other than trying to make reason of things, right? And so we go, well, that doesn't stand the sniff test, or what I just saw doesn't seem believable. And so then part of the beauty of sport is for us to be able to watch things that we've never seen before and be blown away. And I suspect with a lot of this going on around this particular Olympic cycle and everything going on with the Russian doping scandal, that as we see amazing things, one of the first things that pops up into our mind is, was that really amazing, or did we just watch a really enhanced version of an athlete?
Yeah, was that an artificial performance?
Yeah.
Or is that real human limitation being challenged? And no, I agree with you. And you know, it's a cat and mouse game between people who are cheating and people who are trying to catch them. And it's been that way since the Balco scandal. I think, you know, the various governments are trying different methods to try to deter doping and also to try to test it. And for instance, in some European countries, it's now a crime to be doping. And also, one of the nice things I think is that some of these samples are being saved for the long term, and you're starting to see now, for instance, a test for EPO might not have been available in 2004 and 2000, but now they're able to go back to some of those samples, retest them, and at least you can at least know that justice is being served. Now, you're taking away a very special moment from, say, someone came in, you know, like I think Nick Willis, for instance, he had a medal upgraded because the person who beat him was caught cheating. you lose that glory, that moment to be on the podium, to hear your anthem being played, knowing that you just won, you just won the gold medal. But at least, and it may not be a great consolation prize, but at least maybe down the road, justice is being served. So again, it's at least nice to see that while it is a cat and mouse game, it doesn't just end after the competition. It's something that can come back to haunt you further on down the road.
Yeah, it certainly begs the question of what other tools could USADA use in terms of changing that cost-benefit analysis that potential cheaters are weighing, and can you make it so stiff, the consequences, in some way that the thought of ever being caught, whether it's 10 years down the road, 15 years down the road, that becomes problematic. Certainly when we look back at your example of Lance Armstrong, it's hard to make the argument that he might not do it all over again, given how much he benefited from a very systematic approach towards doping. And certainly that loss you talk about is real. You talk about an Alyssa Montagna, 800-meter runner, who finished 2 spots behind 2 Russian athletes who are now named in that investigation and stands to move up. But there are lots of contractual obligations that didn't get bumped up because of that. So she lost money, she lost fame, she lost a moment in her career. And so that story gets repeated over and over again as well. As we wrap the conversation, any final thoughts from your perspective on this issue?
Well, I credit USADA for, they're trying to investigate every avenue. I think they're using every means they have available to try to come to the truth of this matter. I certainly would love to see, just let the facts play out and see what happened. But at the same time, I'm also, as a lawyer, cognizant of, you're trying to put a doctor in a very uncomfortable situation that was a threat to him professionally. And so, you have to be careful when you have, again, an entity like USADA. It's a non-governmental entity that's just supposed to be monitoring, and conducting doping control to make sure that the athletes we send to international competition are clean. So you have to be careful that they're not overstepping their not their responsibilities, but what their role is in terms of ensuring a clean sport. So it's a balancing test. It's going to be a constant balancing test. But I do hope that there will be later on down the road a takeaway from this, such that maybe Congress or and the USOC might take a look, might consider what changes they need to make or enhancements they need to make to USADA to help it do its job a little bit better.
Yeah, it's certainly hard not to be concerned, even in the interest of integrity of sport, about some of the potential collateral damage that can happen when these investigations are taking place. And really appreciate your analysis on this and all of the work that you do. So thank you for your time, and we'll have to do this again soon.
Oh, thank you very much for having me.